Todd, you were up as our cleanup batter, and in particular because this is a Federalist gathering, one of the things you'll be talking about is how the rule of law plays in all of it.
That's right. With a name like Zywicki, I'm used to going last. The topic is a new paradigm for capital and labor, and I fear that we are on the verge of a new paradigm for both capital and labor, and I fear that where this paradigm leads us to long-term stagnation and a really kind of corrupt collusion of big government, big business, and big labor, where there are going to be a few people who are going to do well who are wired in, but that the net effect is going to be long-term stagnation and decline. I'm concerned in three ways about this new paradigm. First is what we've seen already is it threatens the rule of law, contracts, and property rights. Second, it threatens the economy in real time and economic recovery. And third, it threatens our long-term freedom in the free market system through a direct and seemingly intentional effort to politicize the entire economy. So let's start off by talking about how it threatens the rule of law. I kind of got pulled into this through my disgust at the Chrysler bankruptcy case. The one underlying premise of bankruptcy law is what we call the absolute priority rule, which is that we have various levels of creditors, from secured creditors to unsecured creditors down to shareholders. And the linchpin of bankruptcy law has always been what we call the absolute priority rule, which is that secured creditors, more senior creditors, get paid before junior creditors. And in exchange, what you get for that is you are taking on less risk, you get a lower return. If you want to be a secured creditor, you're supposed to have less risk and you get a higher return. If you want to be an unsecured creditor, you take on more risk, you get a higher interest rate. That's not what happened in Chrysler. Basically, what we saw in Chrysler was that there were secured creditors who were bondholders. The ones who have taken up the Supreme Court are the Indiana Pension Fund. So that, and you've got unsecured creditors with the UAW, who had unsecured claims for unfunded pension plans and that sort of thing. In the end, what happened was those secured creditors are getting about 29 cents on the dollar. The unsecured creditors, the UAW, are getting 50 cents on the dollar. It's not clear to what extent this is just a direct wealth transfer from taxpayers to the UAW versus what obviously seems to be what it is taking out of the hides of secured creditors and redistributing to unsecured creditors what would otherwise be the money of the secured creditors. And no, this isn't labor versus capital, right? This is the UAW, who has the ear of the president, stealing money from the retirees of Indiana. And so this is... And the sort of the sham reorganization that went on there of short-circuiting all traditional Chapter 11 processes, a rigged bidding process that basically excluded all other bidders. The whole thing is just a monstrosity. General Motors, the monstrosity is a little bit different. In General Motors, what you have is rather than a redistribution from secured creditors to unsecured creditors, you have two unsecured groups of creditors being treated differently. Now, the good news in General Motors is that they decided to honor the priority of secured creditors in General Motors. The bad news in General Motors is that they decided to honor the priority of secured creditors with no explanation as to why they were plundering the secured creditors in Chrysler and honoring the secured creditors in General Motors. That's almost as bad as the alternative. We got no explanation as to why in one case secured creditors had to pay the price and not in the other. That's what the violation of the rule of law is all about. When you go into bankruptcy and you're playing with the government, apparently you take your chances as to what's going to happen with contracts, property rights, and everything else. Perhaps even more distasteful is the way the government played this game in Chrysler. If you recall, going back to that, there were a lot of things that were really quite disturbing about that. Most disturbing to me was the way that the TARP, all the banks that received TARP funds simply rolled over and acceded to the government's plan to take their money, right? There were these holdouts, including the Indiana Pension Fund, but there are a lot of other secured creditors who were big banks. Why didn't we hear a squawk out of those guys? Because basically those guys were on government welfare because they had taken the TARP funds. So they rolled over and allowed the president to use them as a club to beat up these other creditors who were standing on their property rights. That's scary. And let's call that what that is. That's moral cowardice by those TARP banks. They just rolled over and they gave up their rights and allowed themselves to be used as a tool to browbeat the other creditors in order to save their own hides. The president, you may recall, personally intervened and denounced the bondholders, the non-TARP bondholders, as selfish profiteers and holdouts, right? That's what a property right is, right? A property right is the right to say no. And all of a sudden, he's saying, well, if you say no because you want to stand on your property rights, that's selfish. Well, just think where that leads, right? What if next time the emergency that we have is that we need to steal all the flu vaccine because we've got a national emergency? What if it's stealing some other pharmaceutical rights, intellectual property? As soon as you start getting in this game of saying that there's these imperatives and these exigencies that override property rights and the rule of law and all these other sorts of things, that's a very slippery slope. And I have to observe that for those who expressed passionate concern about the rule of law over the past 8 years as it related to dealing with the global war on terror and that sort of thing, it is certainly a different story today. The bailout of General Motors and Chrysler itself was illegal. If you look at when the TARP was enacted and the money came out of the TARP funds, it's very clear that the TARP authorization allowed money to go to banks, to financial institutions. Secretary of Treasury Paulson went up and said, this money can't be used to bail out the auto industry. Congress voted on whether or not they're going to allocate money to bail out the auto industry, which would have been unnecessary if the TARP already allowed them to do that. Unfortunately, apparently from the perspective of the Bush administration and Secretary Paulson, Congress voted incorrectly. So then all of a sudden the president just said, all right, we're taking TARP money and giving it to them anyway, right? Now, I think that probably some of us have to in the Federal Society, have to look in the mirror about sort of turning a blind eye to, at times, to executive overreaching. But that kind of attitude, where the Treasury Secretary simply says, even though, psych, even though I said we couldn't use it for this, I'm going to use it for it anyway if you don't give it to me, that's not what I consider to be the rule of law. It threatens the economy. So the second point is it threatens the economy. When you destabilize contract and property rights, in a case like Chrysler, you increase the risk of lending. If you increase the risk of lending, that's going to increase interest rates and the price of credit. Now what we have to do is something that I don't think we had to previously consider in American history, which is we have to consider political risk. And those, ironically, you have the most political power are now the ones who are most risky. Automotive industries, probably steel companies. You can sort of go down the list. In my op-ed that I published in the Wall Street Journal, I said that this was Hugo Chavez style strong-arming in Chrysler. And I got an outraged email from a lawyer in New York who said, well, no, it isn't. I object to that because when Hugo Chavez steals people's property, he gives them compensation. And how dare you compare this to Hugo Chavez? Get your facts right. The second thing that's related to that is it obviously runs potential to unravel the whole financial marketplace, right? Which is what you end up with is if you're dealing with companies that have political risk, you're going to be the cost of capital is going to be they're going to have more trouble getting credit. If they can't get new credit, then what the government's going to say is, oh, well, these guys can't get credit, so we need to step in and we need to do it again, right? And so basically what you get is this potential downward spiral where all of a sudden the government turns this into a practice because every time the government intervenes, they upset the capital markets, and pretty soon the government becomes the only lenders. We also see the risk runs both ways, which when the government intervenes to support some parties rather than others, that gives those parties a comparative advantage. Fannie and Freddie is the classic example, right? Everybody knew that Fannie and Freddie had an implicit government guarantee. Want to talk about not pricing risk? Everybody understood that Fannie and Freddie was going to be bailed out, and apparently their bonds traded at a rate that basically treated them as government guaranteed, which turned out to be a correct assumption. One of the reasons why Fannie and Freddie could then gobble up the market was because they had a lower cost of access to capital, and nobody could compete with that. And we're talking about institutionalizing that now with these sort of too big to fail policies and stuff like that. I mean, imagine, and basically if you're too big to fail, that means that you've got a government guarantee standing behind you, which means you have a comparative advantage over everybody else, right? And just think about the dynamics it sets up. Say the government says that the 10 largest banks in America are too big to fail. What do you do if you're the 11th largest bank? You merge with another bank, right, to become one of the top 10, right? And so what you end up doing is creating this this dynamic where you create too big to fail entities, and the real reason is because they can undercut and get a competitive advantage because they've got a government guarantee.